Hello, and thank you for joining me today on my show, Justice Matters. For many of you, my name is Patricia Corrales, or many of you know me as Patty Corrales, and as I mentioned previously, I was a former senior attorney with the Department of Homeland Security, Immigration and Customs Enforcement, or some of you refer to it as ICE, for almost 18 years. And I'm here today to talk about the new unlawful provisional waivers that USCIS finally has finalized their regulations. They finalized these regulations on January 3rd, 2013, and these provisional waivers will be open to the public, to those who qualify for these waivers, on March 4th, 2013. Today on my show, I have the great pleasure of having Juaquin Talleda. Juaquin, welcome.
Thank you, Patty. Thank you for inviting me to be on your show today.
I appreciate you coming. And Juaquin has been an immigration practitioner for over 20 years, and today he joins me. Juaquin, if you could you introduce yourself to the community?
Sure. I'm Juaquin Talleda. I have my offices in Pasadena. I've been in private practice for 20 years, but doing immigration law since 1995, so 18 years. And my practice is dedicated solely to immigration law at this time, or for the last many years.
Well, again, thank you for coming, Juaquin. And today we're going to talk about, I think, something really important for the immigrant community. We're going to talk about today the unlawful provisional waivers. But before we talk about how these waivers apply and when they become effective, let's talk a little bit about what it was like before USCIS finalized these regulations on January 3rd of this year. Before these regulations were passed, or before the provisional waiver regulations were passed, historically, what was the situation with individuals who had immediate visas available to them, but because of them being here unlawfully, they could not complete their adjudication process here?
Sure. Let me give a little background on the whole process. The provisional waiver takes care of a problem that goes back to 1997. In 1997, a law was adopted that said that if you were here unlawfully for more than a year and then you left the country, you were hit with a 10-year penalty that you could not come back. And you could ask for a pardon, but that's uncertain and brought certain problems of separating families, etc. That process was mainly, well, for anybody that had to leave the country. Now, in 1997, they also got rid of a law that allowed people like married to United States citizens or parents of United States citizens, they got rid of their ability to fix their papers here. So now, if you're married to a United States citizen, let's use that one as an example because that's the most concrete. If you're married to a United States citizen and you do not have the right to fix your papers here, you will have to leave and go back to your home country and fix your papers there. So in order to fix your papers, you have to leave and get hit with that 10-year penalty because you had been here illegally. Up until very recently, last year, the process was you left, you went to your interview at the consulate in your home country, and they would tell you everything looks good except you've got this problem. You had unlawful presence for more than a year, you're hit with the 10-year bar, apply for a pardon. The pardon could take up to a year sometimes to process, and if they said no, then you're stuck out there for 10 years. Excuse me.
Separated from your family.
Separated for up to a year, often just while the petition was being processed, and then 10 years if it was denied. So back at the beginning of last year, President Obama introduced this change, not in the law. It's a change in the process. That the way it was proposed last year would have a great difference. He proposed that you, instead of having to leave first and ask for the pardon outside the country, he would permit you to apply for a waiver here before you left. That way, if the waiver was, if they were going to be denied, you'd know that you weren't going to get granted. You wouldn't leave. You wouldn't run that risk of getting hit with a 10-year penalty. And you didn't have to separate from your family for the time period necessary to get the application process.
Let me stop you and ask you a couple questions. I mean, I think you put the provisional waivers in a historical light, and I appreciate that. So for many people who come to me, and I'm certainly come to you, they don't understand, well, I'm married to a United States citizen. How come I can't fix their papers here? Sometimes you can fix your papers here if you've been protected for under under different sections of the law, like 245I, where that application was, that I-130, that visa petition was filed prior to April 30th, 2001. But if you're not protected like that, you will have to leave the country prior to March 4th. You would have to, March 4th of this year, you would have to leave the country and finish fixing your papers or finish the process at the consulate, correct?
That's correct.
Okay. But now, because of this unlawful provisional waivers and USCIS recognizing the separation between the families and the hardship that that poses, they're allowing those individuals who've accrued unlawful presence to apply for this hardship waiver here in the United States.
That's correct.
But you can't apply for it until March 4th.
March 4th. They finalized the process of adopting the change in the regulations on January 3rd of this year, and it becomes effective March 4th of this year. So you cannot apply for the provisional waiver before March 4th.
But what if you already had your interview at the consulate?
Well, that's one of the issues that that has been in controversy since they initially proposed this. They had initially proposed that you would not be eligible to apply for the provisional waiver if you had already had an interview scheduled at your consulate. And now in the final versions, they've pretty much stayed true to that, to what they proposed, but they've clarified it a lot.
And how so?
So now, if you, the way they had initially proposed it is if you had ever been scheduled for, not had your interview, scheduled for your interview, you were unable to apply. Now the way it's been clarified is even if you had previously had your interview scheduled, you could still be eligible to apply for the provisional waiver if the Department of State, which runs the consulates, cancels your underlying petition, or somebody else, and then you get repetitioned by that same person, or some other immediate relative petitions you, and you start a new process under them. Okay. So even if you had advanced your process of getting a consular interview substantially before all these changes started being proposed last year, there's still the ability to kind of start over.
And you can withdraw that underlying petition, have it canceled, and then have that individual who petitioned you refile.
That's correct. And that's only necessary if the Department of State had already scheduled your interview in your home country. The fact that you have an underlying I-130 currently, that it's pending, that the process is going on, isn't a problem. You're still eligible if you meet all the other criteria. You're still eligible to apply for the provisional waiver. But if they had already scheduled you prior to January 3rd, okay, if they had taken steps prior to that date to give you an interview, you are not eligible to apply for the provisional waiver for the family petition that was pending, that was the basis of that appointment.
All right, and I think that's important to clarify. What I've been seeing, or what some of my clients have come to me, they've received emails from the National Visa Center saying, you have applied for an immigrant visa, you have an immigrant visa available to you, it's pending. They give them the option, do you want to continue through consular processing, or do you want to apply for the provisional waiver in the United States? And they ask them to respond. And it's an email, and so the individual, my clients I either respond or my clients themselves have responded saying, no, we want to take advantage of applying for the provisional waiver here in the United States. Is that what you've been seeing that the National Visa Center has been doing? Yes,
I've had quite a few clients that have received not an email, but an actual, snail mail, hard copy letter that says email them with your intentions. Do you intend to seek the provisional waiver? In which case they would kind of stop what they're doing on processing your immigrant visa. Or do you intend just to go forward? And in all these cases, yes, we've been contacting them saying if clients are otherwise eligible, yes, it's our intention to file the provisional waiver application that's called the I-601A as soon as possible after March 4th.
All right, and the waiver, just so that everybody's clear, will be that provisional waiver, as we mentioned at least a couple of times already, will be available on March 4th, 2013. USCIS will not be accepting these provisional waivers before that date. And the waiver, from my understanding, remains the same, the fee for that waiver. It's $585.
That's correct.
And that hasn't changed.
No, that will not change.
The other thing that hasn't changed and there's some confusion about that, is the hardship issue. The hardship issue, whether you were processing through the consulate or you're now processing it here in the United States, is extreme hardship. You have to establish extreme hardship to your United States citizen spouse or parent or lawful permanent spouse or parent. Is that right?
That's correct.
Okay. So I often wonder, how come kids don't count? How come United States citizen children don't count? I mean, separating from your United States citizen child is extremely difficult.
Well, I mean, it's understand what has happened with this change in the regulations. It is a change in the regulation. That is the way that a law is implemented. It is not a change in the law. And it's the underlying law that allows you to get a waiver for the 10-year, the unlawful presence waiver, only if you can show extreme hardship to your citizen or resident spouse or parent. The law does not permit consideration of the hardship to the children in the adjudication of this application. So there's nothing that you can do in a regulation to expand the reach of the law. That's what the law says, and that's what we're stuck with.
However, you can still use children, even though they may not be directly a consideration for the extreme hardship. If the hardship to the parent, the U.S. citizen spouse or parent, is having to take care of the United States citizen children, and that parent or spouse is disabled, certainly the children factor into that extreme hardship consideration for the parent or that spouse.
Oh, sure. I mean, I don't think it has to be quite as dramatic as, you know, the parent is disabled or something.
Yeah.
I think any time that you are, let's say you're the U.S. citizen spouse, okay, if you have children that you would otherwise be left with alone to raise as a single parent, if your spouse is not given the pardon, I think that's a huge consideration for the hardship that U.S. citizen parent is going to suffer.
Absolutely.
So the children, although they are not considered directly, of course they, and I hate to use this term, but they are part of the burden that the U.S. citizen or permanent resident spouse would have to deal with alone if the other spouse is not granted the pardon. So you can, although not consider their hardship, you can certainly bootstrap it into the equation and consideration of extreme hardship.
They can certainly be, the children's being a factor in the underlying consideration of the hardship to the spouse or the lawful, the spouse or the parent, either U.S. citizen spouse or lawful permanent resident
That's
spouse
correct.
or parent.
And if I may, you keep referencing lawful permanent resident and citizen, and I think it's really important to clarify something. You're 100% right that is what's considered in the adjudication and determination of hardship. You look to the hardship to the U.S. citizen or lawful permanent resident, parent or spouse. To be eligible to apply for this provisional waiver, though, it has to be based on a family petition from an immediate relative, which is, an immediate relative is your U.S. citizen spouse or your U.S. citizen child petitioning a parent. So although you can consider the hardship to a lawful permanent resident spouse, that spouse cannot petition you and have that petition be the basis for a provisional waiver. Confusing as heck, I understand.
It is confusing.
You know.
So let's just make that clarification. Let's try to at least clarify that, because I think that's a very important point. To be eligible to apply for the provisional waiver, you have to have an immediate visa available to you.
Well, an immediately available visa based on an immediate relative petition. And the definition of immediate relative under the immigration laws is the spouse of a U.S. citizen, the parent of a U.S. citizen, or the minor single children of a United States citizen. Those are the only definitions of an immediate relative. And it has to be one of those I-130s, those family petitions, has to be the basis for the request for the provisional waiver.
So let's play this out a little bit, okay? Let's give an example for our public, if we can, for our community. So I'm the daughter who's over 21 petitioning my mom, who's been here illegally and who has occurred unlawful presence. That petition is immediate, correct?
Right.
I'm an immediate
That's
relative
correct.
of my mother.
Or
Correct.
she's an
Or,
immediate relative of
excuse me,
yours.
that's
You
backwards.
know,
She's an immediate relative of me.
it's the same, yes.
Okay. That I-130 gets filed and it gets processed and it gets approved.
Right.
Now, my mother has to apply for the provisional waiver here in the United States, but she is not married. There is no spouse for her, and neither of her parents are either lawful permanent residents or U.S. citizens. Correct?
Right.
So, would my mother then be eligible for this provisional waiver?
No, she would not, because she does not have a citizen or resident parent or spouse. So even though she has an immediate relative child who can file the petition for her, she's not eligible for a waiver, whether it's the provisional waiver here or the old process of leaving the country and applying for the waiver outside. So that relationship would not resolve her problem at all.
Okay. Go ahead.
Now, let me change that a little bit.
All right.
Your mom is married and her husband happens to be a permanent resident. The permanent resident husband cannot petition her and have her request the waiver based on that petition, but you, as her immediate relative, can petition her, and then she could apply for the waiver, not based on her relationship with you, but based on her relationship to the lawful permanent resident spouse.
So the spouse who petitions, okay, so in this case, my mother's lawful permanent resident spouse is petitioning her, but she cannot use him for the waiver. Is that right?
It's the other way around. You, the immediate relative, are petitioning, but you don't qualify for her asking for a waiver.
No, and I understand that. So because the citizens U.S. citizen children don't qualify for
Right.
a waiver. But you said let's change the hypothetical around a little bit. What if my mother now has a spouse?
Right.
And he's a lawful permanent resident. He can petition her for her, but if he does, he can't count for the waiver. Is that what you're saying?
Right. He could count for the waiver under the old process. So if she wants to fix under him and go back to their country and request the pardon outside, could do it. She cannot request the provisional waiver under the new process based on that relationship. It has to be based on an immediate relative petition. So only the petition from you, her immediate relative daughter, for her would qualify her to apply for the provisional waiver.
See, this is all very confusing, and that's why it's really important for our immigrant community that they speak to qualified and experienced lawyers who deal in immigration laws before they seek or file anything with USCIS, whether it's this provisional waiver or any other type of immigrant petition. If it's confusing for some of us practitioners, certainly it's confusing for many in the community, so it's always preferable to go to a licensed attorney as opposed to any notarios who can tell you or sell you a bag of goods saying that they can provide assistance and file these waivers for you.
And I'm certain that's happening all the time already.
Of course it is. But you bring up a very important topic. The whole immediate relative and who gets to petition you and who you get to use to qualify for your waiver is very confusing. But let's talk about one thing that I want to make certain that our community understands, and that is, let's say you file for your provisional waiver here in the United States. You don't have to separate from your family while this provisional waiver is being processed by USCIS. But I think what our community may not understand is that you will, once that waiver is approved, you will have the waiver in hand approved. You'll take that waiver, you'll go out and finish processing through the consulate of your home country, but you will still have an interview at the consulate. And at the consulate, there still may be other reasons for which you may not be admissible to the United States. So granting a waiver, having USCIS approve your waiver, while a good thing and a great step at coming back here legally as a permanent resident, does not accord that individual lawful permanent resident status, and nor does it, and correct me if I'm wrong here, nor does it mean that nothing else could be triggered at the consulate interview. Is that right?
That's correct. And that's an important point on the fundamental eligibility to apply for the provisional waiver. The provisional waiver waives one thing and one thing only. That is the penalty that comes from being unlawfully present in the United States. If you have other problems, other what they call grounds of inadmissibility, crimes, fraud, public charge, health issues, anything, prior deportation, we'll get into that, prior deportations, any issues like that that would be additional reasons for immigration to deny you, the provisional waiver is not going to help you. The provisional waiver only waives the penalty that comes from departing the United States after you have accrued a certain amount of unlawful presence. So when you apply for the provisional waiver, USCIS is supposed to do a bit of an investigation to see if there is any other ground for which you are inadmissible. And if they find another ground or suspect that there is another ground, they will either deny your application or return it to you with the money. I can't imagine that they're going to return it to you with the money, but that's just my opinion. They would deny your application. It's really important that somebody who is applying for the for the provisional waiver investigate their own immigration history and their own criminal history, and they got to make sure that they have no other grounds of inadmissibility, because one, they'd be wasting money and time in applying for the provisional waiver, and two, if they've got something in their background that they've been lucky and USCIS didn't catch it at this point, it still may get caught when they get out to the consulate.
Absolutely, and if at the consulate, so if they have a situation, if an individual has a situation where we're looking at something other than unlawful presence, they can't take advantage of the provisional waivers that now are becoming open here on March 4th. They would have to still leave the country and apply for that waiver at the consulate, and any other waiver for whatever other basis makes that individual inadmissible, if there are waivers. Because if you make a false claim to U.S. citizenship, for example, there is no waivers for that. So that type of situation requires really an analysis with an experienced immigration lawyer. And Joaquin, I thank you for your experience in this as an immigration lawyer and for helping the community. I want to thank you today for coming and talking about these provisional waivers. They're very complicated, but thank you for coming.
They certainly are very complicated.
And if people have additional questions that they'd like to ask of you, how can they reach you?
Well, they can reach me at my office in Pasadena, and my email is LOJAT, which stands for Law Office of Juaquin Talleda, at ymail.com. Thank you, Patricia, for inviting me to be on your show. I appreciate it very much.
For more information, you may contact me at patricia.M.Corrales@gmail.com. Thank you.